Jeffrey, we're going to have 2 hours to go into many of the details like that, but I want to read a little more broadly part of Sotomayor's dissent. She says, under the majority's opinion, if a president, quote, orders the Navy SEAL Team 6 to assassinate a political rival, immune. Organizes a military coup to hold on to power, immune. Takes a bribe in exchange for a pardon, immune, immune, immune. Does this ruling expand presidential power as we know it?
It does expand presidential power as we know it. And the core of Justice Sotomayor's dissent is that even when you have an unofficial act, like ordering the murder of your political rival, you can't use evidence from an official act to prove it. So Justice Sotomayor gives the example of, say, a president says, I'm going to do anything possible to stop my opponent from passing a bill, and then he orders him murdered. You couldn't introduce the overt evidence that he said, I'm murdering him because I want to stop him from passing a bill, because that's an official act. And that's why the core disagreement is Section 3C of the opinion, which has to do with evidence. Can you use the official evidence to prove the unofficial evidence? Justice Barrett came up with a compromise position. She would not have created this broad new immunity at all. She would have just asked, does the statute cover the presidential conduct, and does that unnecessarily intrude onto a core executive function? If the court had held that, there would have been far less disagreement between the two sides, because Justice Barrett would allow evidence of those official acts to prove the unofficial acts. So that was the core of the disagreement. Justice Barrett did not join Section 3C of the opinion. And in that sense, the majority unnecessarily embraced a sweepingly broad vision of presidential immunity that exacerbated the division between the majority and the dissent and unnecessarily polarized the country.
So when you have a decision that, as you say, is this broad, how does a court determine what's an official act and what isn't?
Well, that's the crucial question. And what makes this decision so hard to apply is it sends it back to the lower court and punts all those hard questions. It says you've got to disaggregate the various encounters between President Trump and first his vice president, second his attorney general, third the state election officials, fourth his own tweets. And in each case, the lower court has to make a determination about whether that's an official or unofficial act, subject to being reversed by the Supreme Court. And frankly, it's just not obvious in all of those categories how a court could hold, because it's a mix of official and unofficial acts. Take the example of the vice president. He's urging the vice president to commit an act that the vice president himself concluded was unconstitutional, but how is a court to conclude ahead of time whether the conversation itself was an official as opposed to an unofficial act? That's what makes the test so hard to apply. And that's, in practice, what creates this broad new swath of immunity, even when the conduct in question is concededly illegal.